Okay, it is 8:30 p.m. Tuesday, October 24th, 2017, and we are already in week 4. I remember I told each and every one of you that we would be getting the calendar moves pretty fast, and it's very important that you continue to keep up with your assignments. I am going to be submitting grades for week 2 for this class probably by the end of the night, and so keep moving forward. Week 3 is the last time you have a project until you get to week 8. So weeks 4, 5, 6, and 7, you won't have project. You'll just have the written assignment and the discussion post, and of course your reading. And so I'm going to go ahead and get started, so you can make sure that you to hear me. You have to activate. You have to activate your audio. You have to activate your audio. Okay, so I'm going to go ahead and get started. Sharing the screen. Okay, I'm going to go back and do this. That's what I want you to see. Okay, so you can see now information concerning the course, who I am, the information for tutoring, and you will find that, okay, I see Catherine is joining. Let me stop sharing a minute to make sure that you're all set. Make sure, okay, now you can hear me. All right, I know before you were in, you couldn't hear me, but you have to always activate your audio. Very important. So I'm going to go ahead and go back to where I was, sharing my screen. So now, reminding you, make sure you use your rubrics to check your assignments. Your written assignment rubrics are in here, and I emailed them to you at the beginning of the quarter, and your project rubrics for each week are in here. And then, of course, your discussion post rubrics. These are very important in terms of making sure that you maximize the points for each of your weekly assignments. So this is week 4 lecture. And so after this, we'll have 3 more lectures, 6, 8, and 10. And as I said earlier, the quarter is moving very fast. And so I also send you the link of the recordings. If you can't find them, all you have to do is copy and paste the link here. Same thing here for week 2 lecture. But the open house one is one that's always good to refer to for the rest of the quarter. So moving right along here, I'm going to go right to week 4 announcements. Okay. Crimes against people and property. And so you were to read chapter 7 and 8 of Criminal Law and Procedure. I also sent you on Sunday the program, the PowerPoints for this week and the additional information that I provide to help you with an outline of each chapter. And then you're going to complete the activities, crime against people and property. And so that's where we are for week 4. Now, then your discussion posts, robbery, burglary, and theft. And you're going to hear a little bit about that tonight during the lecture. And then your written assignment concerning rape shield laws. Make sure you satisfy the requirements in the written assignment for that week according to the rubric. And then, of course, the quiz. The quiz. I again encourage students to take the quiz at the very end of the week. So, Catherine, can you hear me? Just type in the box if you can hear me, yes. And if you're not able to hear me, let me know. But I think you can hear me. Okay, great. So anyway, then please take the time to complete the mid-quarter student survey. It's feedback that I look at, and it helps me so we can have a better second half. So, and I try to, like I said again, remind students again that grades are not always going to come as fast as you think they are because of the way that our setup is. Week 3 assignments completed Sunday. You're not going to get grades until probably next week. And then the week 2 assignments, which I'm a little bit behind, but because I shared with all of my students that we had a death in the family, and we just had a service on this Saturday. So I'm kind of rebounding from that. And so at any rate, just hang in there. I'm going to keep you up to speed. And then I already told you about my motto, adversity springboard to success. So now and then we're going to go until 10, and no matter where I am at 10 o'clock, I'm going to cut it off. So let's take a look at the course calendar real quick as a reminder of everything when it's due. You can see that we are at week 4, and that's reading assignment due to, and then your initial post, your live lecture, and then your reply post. Then the mid-quarter survey, your written assignment, the one we just talked about a few minutes ago, and we'll talk about some more, and then your quiz. And then you'll notice all the way down, you keep going down, you'll have written assignment, quiz, until you get to week 8, which will be in November. And by the time you get to week 8, we only have 3 more weeks to go. So you'll have week 8 and then 3 more weeks to go. All right, so now let's jump right into the module. I do want to call your attention that all of your written assignments are APA format. You go back to the course homepage, the open house. Just for a minute, I'm going to go back there. There it is right here, additional course information. Very important about requirements for research, not using your textbook as a sole source. And then the APA. Many of my students have really good papers. They run through Grammarly, the percentage is low, but then you lose right off the bat for projects, 5 points, and for written assignments, 3 points. So you can go from a 20, which is most all the written assignments, except the projects, which are 100 points. And so you could automatically almost drop a grade by not doing APA. And APA full credit doesn't get to you until you do both citations and references and a cover sheet. Very important, very, very, very important. And then you have to conduct some research. So I wanted to go back to that again because you want to make sure that you keep up with that. So now let's continue on, and let's get back to our module 4 where I was heading. Again, these are your assignments. Your written assignment concerning the rape shield laws. We're going to talk about that tonight. Notice the requirements, 2 to 3 pages. If you complete less than 2 pages, page and a half, page and 3/4, you're going to lose points. So you don't want to do that. And then you're going to make sure you answer these questions. Cover all 3 of these bullet points in your papers. providing, once again, APA format. Your written assignments, all APA format. I keep saying it over and over. Some of you guys say, why do you keep saying it over and over? Some students still haven't gotten it. And every week I grade assignments, I automatically look at it. So make sure that you have complied with that. So then your next assignment is your discussion post. And this is a very interesting one. A lot of students miss out on the correct response to this. Remember, it's due tonight, your initial post by 11:59 p.m. Central Standard Time. Then your reply post due Saturday. So you're going to have a chance, if you're hearing a live lecture, to hear me elaborate on the differences between some of these crimes and what some people may miss. So you're going to be asked to determine, based on this fact pattern, whether Debbie is guilty of robbery, burglary, theft. One of them, two of them, or all three of them, and then you're going to explain why, the differences between the crimes and the likelihood of Debbie being convicted of all three crimes. Okay? And then your quiz, of course, as I remind you again, I would recommend taking that on Sundays, but it's up to the students. Some of you have already gone on and taken it. And some of you, most people who take it then would have scored better if they'd have gone through all the material and made sure that they were well prepared when they take the quiz. So now with that in mind, let's go to the actual lesson content before we get to the lecture. Again, lays out your assignments. Again, remind you to take the mid-quarter survey. Talks about the quiz, the discussion post, the written post. And then crimes against people and property, which is an activity section, which we're going to go over here in a minute. And it just shows you the definitions of these things, these terms. You want to make sure you're familiar with these, each of these, including larceny, false pretenses. And then you do this little drag and drop where you have, for example, the unlawful use of force by one person against another that entails some injury or offensive touching. Can either of you type in which one of these fit? Which one of these fit? Which of these fit the answer to this first part? The unlawful use of force by one person against another that entails some injury or offensive touching. Which one is it? Either of you? Okay. Catherine says assault. What about you, Brenna? What do you say? You say assault. Okay, I'm going to do that, but I already know what's getting ready to happen. That ain't it. This is it. You're going to learn in the lecture tonight that the thing about assault is that you will find that it doesn't require touching. That there's no touching. There is no touching. And so as a result, one of these is assault. Which of these is it? Here it is, I'll tell you. Here it is right there. Notice what it says. The intent to inflict. You intend to hurt them. Intent. It just says intent. The difference here, it says touching, offensive touching. So you make contact. And we're going to be talking about that in a few minutes. So I'm not going to go over all of these, but it's good for you to do these exercises. And they help you to become familiar with the terms that help you to better understand what's taking place in the module. So with that being the case, I'm going to leave that. Yeah, that's exactly the point. You're right. That is exactly the point. And that's what I always say to students. These little things help you to prepare for the quiz. Absolutely, you got the point, and that'll bode for increased scoring. So definitely. So let me get right into it's a 1:45. So I got about an hour and 14 minutes before I adjourn. So let's try to go through as much of this we can. Now, offenses against persons, where we're talking about individuals being affected by the actions of the person, things that they did. And so with that in mind, assault offenses. Now, crimes against persons are based on state law rather than federal law, pretty much. Now, under common law, assault and battery were misdemeanors. But today it is still misdemeanors in many cases under statutory law. And so now, though, assault and battery of like public officers are felonies because we want to discourage people from attacking public officers. And public officers don't necessarily mean the police, don't necessarily mean the fire. It means mail persons. It means mail delivery people, or it means utility people, the power people, the light, the gas, the water. It even extends, I think, now to the cable and phone companies and people like that. These are felonies because of their capacity that they're operating in at the time of the assault. Aggravated assault and battery are also felonies. And aggravated assault, okay, let me just back up. Now, assault. Here's assault. Now I'm going to do this. Presuming that there's someone in my vicinity. When I do this, and I raise my hand to that person, and I put that person in fear or expectation of being struck or touched or hit, that raises the issue of assault. That's an assault, remember, based on what we learned from that little exercise. And then battery is actually the contact, the touching. So if this was somebody else's arm and it's actually mine, you can't commit assault battery on yourself, okay? It has to be another person. So anyway, assault and battery. So you hit them. And when you hit them, that contact is battery. Now, if it turns out that you used something that, like a weapon, dangerous weapon, or in the instance, you can use your hands if you are a registered boxer or a professional boxer or either a registered martial arts person. Then that's a deadly weapon. That's a weapon. So then it moves from the level of assault, that when that person raises that hand, to battery itself. And if you happen to have a weapon or something in your hand, again, even if you don't strike them, it's still aggravated assault, okay? And then battery is when there's contact made with that item and so forth. And these are felonies because you got to recognize that if you escalate the injuries on individuals, you move from misdemeanor to battery, which, by the way, I'm going to ask this question. How do you know if a crime is a felony or a battery? I'm sorry, felony or misdemeanor? How do you know a crime is a misdemeanor first? How do you know? What is it that helps you determine whether something is a battery? I'm sorry, I keep saying battery. Is a felony or a misdemeanor? Any ideas? No challenges, no takers. Take a shot. How do you know that something is a misdemeanor? There's something very simple, and once you learn it, you'll probably never forget it. Okay, no one's saying anything, so I'll just tell you. It's based on the sentence. The sentence. So, if a crime is committed and the sentence for being found guilty of that has a possible penalty of up to a year in jail and or a fine, it is a misdemeanor. If it goes a year and above, it is a felony. That is it. That's it. And you can normally determine it, and you can probably pay attention to the fact that misdemeanors are, quote, minor offenses, therefore sentencing is not as serious as a felony. When you move over into felony status, that's when you reach the stage of more time in jail. And I'll put it this way. Many times individuals that commit batteries or misdemeanors go to jail as opposed to prison, or they qualify for probation, supervision, or other things of that nature. But if you commit a felony, it depends. It depends. It depends. It depends. It depends on what that felony is. You would stand a chance to go to the penitentiary or some other intermediate sentencing, such as house arrest or something like that. Anyway, that's the difference between the two. Never forget that. Never forget that. So I've already talked about these, so I'm going to just pass through real quick. Assault, aggravated assault, battery, and aggravated battery. And so I've already covered that, so I'm going to keep moving. And you'll notice that, again, I've covered this. What assault doesn't require physical contact, battery does. And some examples, such as shooting and missing a person, threatening someone with a weapon, aggravated factors using deadly weapon, or something that might cause great bodily harm. And then just a simple battery goes down this list here. Then this one, excessive discipline of a child, that's something that happens in parenting, and that there's a big debate about that. But these are batteries. Again, it gets back to what I said a few minutes ago. Great bodily harm. Here's an example here of a situation where great bodily harm is involved, which is debatable. So here's a scenario. In California, child abuse is the willful infliction of cruel or inhumane corporate punishment that results in a traumatic condition for the individual child. Well, here's a case, a scenario. Chew on this a little bit. 4-year-old Timmy threw his breakfast at his mom because he was unhappy that they weren't going to Disneyland for the day. That right there calls for some action from the parent. So what the mother does is she puts him in timeout. Well, that's not what I would do. But because I don't, are you kidding me? You did that because you're not going to get your way? No. Anyway, the mother follows the steps of putting him in timeout. But Timmy continues after that. Hits his mom. Okay, gone to the next level. And spitting. I don't know if any of you have kids. I have 8. They're from 46 to 9. I have never had a kid in my house or my child to get away with that kind of thing. I know one that tried it, but anyway, it's a bad career move. Anyway, his mom wants to give him a spanking on his butt, which is fine, but she misses it and hits his head instead. He falls on the floor, hits his head. The diagnosis is a concussion. Now, is that child abuse or not? No. In my opinion, it would not be, because it was unintentional. Notice it says child abuse is the willful infliction of a cruel. Was it cruel for her to want to hit him on his butt? No. Or inhumane. Was it inhumane hitting him on his butt? No. But here's the deal. I can imagine what happened. He's already shown that he's tough. He's spitting and doing things he shouldn't do. He's probably wrestling. And so with that case, the mom could miss, and so forth. So no, that is a situation where I, as a lawyer, would defend that parent and not allow that child to be taken away from that parent for child abuse. And so, but we get to the great bodily harm. So here's the deal where I explain great bodily harm. And it says there's no consensus. Great bodily harm is something that the average person, I think, would be able to identify by what takes place with a child. And so based on all the surrounding circumstances that take place, can be determined that person is guilty of inflicting bodily harm. But accidental in situations, of course, there's accidents that happen when a person uses the wrong thing. Let's say, for example, you pull a gun out to discipline your child, and then you pull the trigger on it. Well, in that case, then you didn't intend on it, but it's still going to end up being great bodily harm because of the fact that it could be murder if the kid actually dies, because you're using a weapon or something that in itself speaks to the ability to be able to seriously injure or take the life of an individual. So anyway, you begin to get my drift in terms of that. The prosecution and defenses of these crimes, simple assault and battery, the prosecutor just has to prove the act and not specific intent. So that's how you get simple assault and battery. But when you get with aggravated, the prosecutor has a higher requirement, and that it has to be proven that the person intended to do great bodily harm or to commit a felony, one or the other. So if they're able to tie it to that, then it becomes assault and battery in that situation. Defenses that are commonly raised by defense attorneys on behalf of people is that saying that the degree of force wasn't really that bad, but there are some arguments that statutory law defines degree of force can be used by teachers, police, and so forth. In other words, excessive force going beyond what's necessary in the circumstances can result in a person being guilty of aggravated assault as opposed to simple assault. But a defense is that the law, it says that teachers or police are given a certain level in which they can exercise some level of force depending upon the circumstances. There is a whole lot of excessive use of force that's been alleged against individuals by the actions of police officers. So anyway, the bottom line is that you have to operate on the basis of what's necessary to get control of the situation. Sometimes it requires deadly force. Sometimes it doesn't require deadly force. And if you use deadly force in a instance where it's not, then you're going to get to excessive force. And then when it comes to teachers, there's been a movement that teachers are not permitted to exercise corporal punishment. That was different. When I came up as a kid, our teachers had paddles, like the name's Mr. Rogers. I'm not talking about the teacher's name, but that was the name of the paddle or whatever it was that was used, and it was used on us as kids sometimes. Anyway, some defenses to being charged with these, it was not intentional, as in the case of that child, that under the circumstances it was reasonable, or that you were exercising self-defense to defend the person or property of yourself or another. But I can tell you that the level of self-defense depends on what specifically you are defending. And I can tell you that the level of self-defense is great for individuals who are protecting someone from serious bodily harm. Mayhem, you don't have to worry too much about it, but it basically means purposely injuring a person so that they're not able to fight back. And in most states, it's in the statutes where, for example, if you try to disfigure an individual, you pour acid or some caustic solution, hot water, or do something. And all the prosecutor has to prove is general intent. And most of the crimes under mayhem are now under aggravated murder and attempted murder based upon what I just said a few minutes ago. So you won't see mayhem, you'll see aggravated or attempted murder. Hazing, it's going around, and you know, you've heard of hazing, intentional reckless or physical harassment for a person to be initiated into an organization, fraternity, clubs, sororities, team, blah, so forth and so on. We just had one here in Illinois at one of the Christian colleges, and the point of the matter is that there are some crazy things that kids are doing and people are doing, and they can result in death or serious injury. Most colleges and universities don't allow hazing for obvious reasons. We didn't have hazing when I was coming up. And then here's an example of hazing, and I'm not going to go and elaborate on that because I already kind of talked about that. Stalking, oh my God, basically involves somebody under surveillance and they're made to feel uncomfortable, fearing bodily harm, sexual assault, or being confined or restrained. And that person is placed in reasonable fear of injury. And it is such a serious offense now that has taken place in large numbers. In 2006, I don't know, they should come up with some more updated numbers because we're 12 years over that. At this particular point, it said in 2006, 3.4 million persons 18 or over were victims of stalking. And in 1990, California made stalking a crime. And in most jurisdictions, stalking is a crime. And the federal law, as part of the Violence Against Women Act that is implemented in the states. During the 1990s, a number of defendants attacked stalking grounds, saying that they had their rights to be where they were, but most courts have upheld the constitutionality of stalking. They say, I didn't do anything. Well, it's a pre-designed form of putting a person in an uncomfortable position, so to speak. Now, that has elevated with technology to this new crime, which is cyber stalking. In Illinois, it is actually a felony to cyber stalk because of the fact that a person can even be demonstrated to have taken their lives. There's been instances in Facebook and on other social media websites, but primarily in Facebook, where individuals have been so much stalked through the internet and on the World Wide Web that they have committed suicide or something of that nature. But it's very simply the same thing as I said, harassing a person using online contact. That's the addition. And it's very, 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 very serious. There's been some psychological problems that people have suffered because of cyber stalking. So many states now include cyber stalking, but Illinois is one that we've had it for a little bit here. Rape and sexual assault, forcible rape. So, you know, this is, I'm not to spend a lot of time with. It's what it is. It's forced sex with a person against the will of that person. And then we have what we call statutory rape. Is a strict liability offense, which means very simply, people, I don't care what he or she looks like. I don't care if they look like they are 22 or 18 and above. If they are minors, you will be charged with statutory rape. I don't care if they gave consent, because they don't have the capacity to give consent under the law and are protected under the law from giving consent. You will be guilty irrespective of that. And, you know, I've had people, I tell them, I says, in this day and age and time, kids are growing up and looking more mature. When I was 14, I looked like a 14-year-old kid. I looked like a little kid. I was a little kid. Now 14-year-olds, some of them are 6 feet. Some of them are 5'11". They're big. They got mustaches. They're growing beards and all kinds of stuff. I didn't have any of that stuff. But anyway, and the girls now, you know, same thing. They're more mature, fast, and growing up. And so individuals have to be aware of that. I, as a lawyer, would tell people, just leave people alone and don't get caught in. And, you know, most people don't say, can you show some ID or something like that. I have even seen, and you need to hear me, instances where individuals tried to use the defense of the ID that the person provided was fake. They still were guilty because it is a strict liability offense. Just prove that that person was actually at that time a minor and you had a sexual act with that person, period. Marital exception, the Haley's rule, remained valid in England until 1991. A person could be charged as an aider or abettor if they assisted or procured another person to rape their wife. Then they could. Now, be aware that the law pretty much protects husband and wives from being charged with rape with their spouses when they're not legally separated or something, or there's an order of protection against them or something like that. But if they live in the house, you know, and that kind of thing, and if there's a disagreement about it, and then the person goes on, they could probably not be charged with rape. Now, if they end up creating injury to that individual in the process, then they might be charged with domestic violence in terms of battery or something along those lines. And then, again, this is statutory rape laws. I've already covered that. As again, the bottom line is you're at the mercy of the court. Now, some people think that statutory rape laws are, as they say, out of touch with today's sexual mores. Well, people, the law and morals don't necessarily have to be the same thing. It means very simply that, okay, people are not going to be able to do that now. That's the way the law is now. I don't see it changing any. And so some people said it deprives women in their late teens of exercising a personal choice. Well, guess what? The law has to protect the ones who don't understand and know. And, it's like I have 6 daughters. I have 7 sisters that are alive. I have had 8 altogether. They're all younger than me. When they were younger, mm-mm. I don't care. People get out there and they do stuff. It's not based on your morals. It's based on what the law of the land is in that area, and it's for protection. Period. Enough of that. Rape laws now are gender neutral. That's why you heard me saying male or female. And there's some movement towards criminalizing forcible sex between spouses, and I already kind of elaborate on that. But there's a line that they don't want to cross, and that's getting into the affairs that are considered as private. The bedroom is supposed to be a sacred place, but the fact of the matter is that, again, you get to a point where you get to the aggravated assault or the assaults of individuals or batteries. If you, for example, use a foreign object, rape is expanded, and battery, sexual battery is based on the extent or degrees. And then we come to something that you, right now at this particular point, you ought to be paying close attention to what I'm about to say about rape shield laws, statutes that are specifically put in. Let me give you a little history, and I'm helping you out here. Is that rape shield laws didn't exist early on. In fact, when I first started practicing in 1978, and I didn't do a lot of rape cases for obvious reasons. I told you it would be unfair. So I did only a few, and I did real good when I did the ones I did do. But anyway, the point of the matter is this, is that it used to be that the sexual history of individuals could be used against the victim, and they would be placed in a situation where they can possibly face interrogation during a court case or by law enforcement. But rape shield laws were put in to protect the disclosure of sexual history, and oftentimes to protect the identity of rape victims. A lot of times you'll see Doe or the person not done. And so with rape shield laws, they are also conducted in situations where there is evidence or information. Instead of being presented in open court, there's what we call in camera. And you see that in your written assignment this week. And that means very similar. It has nothing to do with a camera. What it means is a closed session with the judge, usually the attorneys involved, and the issues are discussed, but they're not out in the public and they're kept private. And the reason is because many people, and it already makes sense, are embarrassed about coming forth when they've been victims of rape because of the way that they feel that they will be treated. Not all rape victims know about the rape shield laws. And to be honest with you, they still feel the stigma that society places on individuals who are rape victims. They asked for it or they did that. That's nonsense. But that's the kind of stuff that would take place. But the rape shield laws were an attempt to change that, and I think that's a good move because of the fact that just because you're promiscuous with someone doesn't mean that someone else that you choose not to be promiscuous with has the ability to use that as defense, and that's the point. And then this goes with what I said. These are all the things irrelevant. It says nothing about the question. So, with judicial reform, victims of rape should receive no more scrutiny than other victims. In other words, not to be like cross-examined, like they asked for it or created. Women are not required to resist. Is also one requirement. There used to be one. Oh, did you try to resist? Well, hey, listen to me. And common sense stuff. And I used to, I'd sit in court and hear stuff like that. The question is, if someone's got you in a situation that you feel that they might kill you, and I have seen cases where that happens, well, you're not going to resist because you go through this. It traumatizes you, but you don't die, at least physically. Mentally and emotionally you might. But the point of the matter is that the whole point in a nutshell, people, is for you to be aware of the fact that this was a good move to protect, at that time, intended women, but now it also protects males because it's gender. And then it also definitely, with the same-sex situations that take place as well. So it's gender neutral, but it's good. It's good. What does that mean? People who don't want to be bothered, leave them alone. Sodomy. We get into oral or anal sex between persons and using animals and beasts and stuff. Sodomy, it can be either consensual or non-consensual. If it's non-consensual, then we get into the same thing as rape. Unconsensual sodomy is rape, period. Consensual sodomy, on the other hand, is not a crime because, again, we get to the point that both parties are agreeing. And the Supreme Court has said that states may not, I repeat, states may not prohibit consensual sodomy between same-sex partners, what I was talking about earlier. So the point of the matter is that, again, the courts, again, trying to hands off of the private lives of consenting adults. Go back, Richard, right? Here we go. In individual cases where individuals commit crimes, we are now almost all aware of the fact that individuals who are found guilty of sexual acts are required to register. And 1994, Megan's Law involved a young girl where she was assaulted and raped. And my recollection is I think she was killed too. But anyway, that a law came out, and we called it Megan's Law back in 1994, that requires upon release from prison that the registration is required with local enforcement agencies, providing where they live, and it's publicly available. In our jurisdiction, you could go to the county sheriff's department in the county you live in, and you can find registered sex offenders. And there are arguments and debates saying that the laws are unfair. And here's the point, and I agree with some of these things. They say they include petty offenses, such as public exposure, such as urinating in the park. Well, it depends. I mean, I understand that point. A person who has to relieve themselves and they can't make it to a washroom or something, and they're trying to not do it publicly, but they're in a public place, they're not in a bathroom, then in that case, behind their car or something on the side of the road or something, and they can't help it, that person has unfortunately been charged with public exposure. And it kind of unfortunately labels people, and they are required to register as sex offenders. I think that's going too far. I think that's going too far. And so what happens is people are punished in a situation like that. Then we get to the issue of debate about saying that the law for registration punishes people based on status, whether in wrongful acts. Well, the point of the matter is that individuals who have committed these acts, unfortunately, there is a propensity demonstrated that when people are released, they still continue in that because it's a sickness. It's something that they do. And we have seen, and you know, that individuals are forced to stay away from schools, kids, and all those kinds of situations. But it's for the protection of individuals, and it's a very serious offense for a person to constantly find themselves in situations. Pedophiles, especially, we have a lot of that we deal with. I remember when we were looking for a house, we ran the check and we found that on that block there were 4 registered sex offenders. That was the deal breaker. The house was nice, but we didn't get it. We didn't want it because of that. So we're in an era right now where you almost have to be made aware of who's around you. And somebody once said, well, why is it that these individuals have to register, but other felons, such even the murderers, don't have to? And again, it gets back to what I just said a few minutes ago, the propensity to repeat itself and the commission of the act all over again. And notice what I said. See, look, Smith versus Doe. See what I told you? This is a 2003 case in which the Supreme Court addressed whether Alaska's Sex Offender Registration Act could be applied retrospectively to individuals who were convicted prior to the implementation of the act. And here's what happened. 2 defendants challenged the statute because they said it came after they were convicted of the act, that the statute was punitive in nature, and punitive statutes can't be applied retrospectively. Punitive. So the court said, no, this statute is not punitive. It's not about punishing. It's about protecting the public. And so as a result, the court says that the law required even individuals who had committed offenses prior to register. And that was the way that the law was. And I can see the point, and I can see the other side's point, but the person didn't commit the offense or not dissuaded from committing the offense because of the registration. But what the registration done was put in place, once again, to protect the public, period. And then there's some examples of sex offender registration laws. Person found guilty of being a party to the crime of child molesting because she let her 15-year-old daughter have sex with a boyfriend. The couple were later married, but Ms. Allison will spend the rest of her life branded as a sex offender, and rightfully so in this situation. The child's 15, and she gives her child, please, give me a break. You know, I have no sympathy for this individual who committed this offense. This child now is traumatized, and her adulthood is taken away from her. Her virginity is taken from her. Her opportunity to enjoy life as she should as a healthy person, having a healthy sexual relationship with her future mate or partner. That's yes, she has to be registering. John Cooey, a man with a long criminal history and a history of sex offenses against children, who kidnapped, raped, and killed a girl by burying her under this. This is an example of what I was talking about earlier. Currently, about 750,000 sex offenders are registered in the United States, and that number is going up. And so then, again, we already had a discussion about whether or not those individuals should register, and I already explained that. Okay, that's child abuse. We've almost kind of talked about that a little bit. Physically, mentally, or emotionally endangering the welfare of a child. It's increased, and the reason it's increased, quite honestly, is because the way that the law is being written to protect children. assault, battery, we already talked about that. Neglect, where you don't provide for a child. Did you not know that if you don't take a child to the doctor because you don't believe in doctors or it goes against your faith, that's child abuse, because the law says that you can make the decision for yourself, but that child you cannot, and the courts will step in to protect that child. And so it's a strict liability crime because of the age and vulnerability of the child, to protect the child. Primarily misdemeanors, but depends on the extent. And also there are what we call mandated reporters, of which I am one, require medical professionals and social workers to report instances of suspected child abuse. That goes with teachers. It goes with me as a pastor. It goes with almost all our positions in terms of that. We do have online students, but the fact of the matter is that if there's something on campus, oftentimes parents will bring their kids, even if it's the academic awards program, or if it's a graduation, or something that involves that, then and we observe something of nature to see where a child is being abused, we have to report that. But we have a process in our school as to how to do it, but it is the law. It is the law. There is an argument, and I kind of understand whether a drug use by a mother constitutes child abuse. Where I can say this already, that it's adequate enough that if a child is born with drugs in their system, at least in our jurisdiction, the Department of Children and Family Service, which is a child protective agency in Illinois, will step in and take that child and place that child in either a relative's home or either in foster care for their protection. So the key thing is this, is that the child is vulnerable and someone has to protect that child. And so the courts, usually in juvenile court, there's what we call abuse and neglect, and that takes place in those courts. Spousal abuse, physical, emotional, or sexual abuse of one's husband or wife. Courts can issue, as I said, protective orders, and then there's the interstate law that means if you cross state lines, committing a violent crime, the Violent Crime and Law Enforcement Act of 1994 is there to protect individuals. This person was convicted of kidnapping and interstate domestic violence for assaulting his wife and driving her around West Virginia and then crossed over into Kentucky before he brought her to an emergency room. The state would not be able to enforce it without the fact that you cross state lines, and therefore that law is in place. Same thing with the elderly, infliction of physical or mental harm on the elderly, usually through state and local regulatory agencies, primarily civil, but can be criminal. For example, here in our state, we are pretty tough with that. I'm glad to know that because I'm 67. But seniors are vulnerable. In Illinois, it's a felony to intentionally or recklessly cause injury to a vulnerable elderly person. So here's a case right here, an example, and this kind of, gets you to realize, yeah, this is really ridiculous. Dale and Janice Simister's uncle was brought to the hospital. The hospital staff said that they noticed that the person hadn't been fed, was covered in urine and dried feces, and that the person laid in a fetal position, which probably resulted from some kind of abuse or something that was taking place. Well, they were convicted of elderly abuse in a situation like that. And so remember what happens. You start out being protected by the law with strict liability for a child. Then you get to a stage where you're a senior and you're not able to take care of yourself, but there's a caretaker or someone responsible, and they take advantage of that. That is where we get into abuse of the elderly. False imprisonment is just simply unlawfully. It's not like going to jail for some crime you didn't commit. It means that that person is restrained unlawfully. And not all states have laws of false imprisonment that make it a crime, and primarily treat it as a misdemeanor. Some scenarios are if you're unlawfully arrested by the police. Prison wardens don't release the person after they're supposed to be released on time. You are stopped by the store detective or the storekeeper for shoplifting, and it turns out that you really didn't. An overzealous male does not allow their female companion, and vice versa, to leave the apartment without yielding to their sexual demands. That's an example. Those are examples of false imprisonment. Kidnapping, forcible abduction, carrying away that person, and is classified as very serious because you put that person, they're not free to go. And then there's aspiratation, which is basically carrying away the property of the individual. Federal Kidnapping Act came about, federal law, if you cross state lines, after the Lindbergh kidnapping. Lindbergh kidnapping involved taking a baby across state lines and those kind of things. Taking hostages as well, and then crossing state lines in situations. Defenses say, well, I didn't really move that person, or the person consented. That second one especially, it's ludicrous, because if you forcefully abduct the person, and they can say, okay, you can take me, you can keep me, that doesn't necessarily mean that they willfully did it because of all the circumstances involved. Child snatching, common thing that happens primarily in a custodial situation. A parent conceals the other child, and they got the Uniform Custody Jurisdiction Enforcement Act, which gives the feds, the federal agencies, and the ability if a person continues jurisdiction for custody in the home resident of the child. So they brought them across state lines. But the Parental Kidnapping Prevention Act is designed to prevent the jurisdictions fighting over child custody matters, reduce the incentive of parental child snatching. In other words, just because you take them to another state, you're still in harm's way there in the situation there. Okay. Civil rights offenses, well, all rights are protected by the federal and state constitution. We don't want to discriminate against individuals, even if they're charged with a crime, and should be treated with respect and should be treated equally. And based on the instances of the situation, not based on whether it's a black person that commits the offense or a Hispanic person or a Caucasian person. It's based on anybody who commits the offense. And that's what it means when it says your civil rights are protected. Protect individuals from injuries conducted by public officials or other persons acting under authority of the government, such as law enforcement, in the situations where there is excessive force or an unnecessary action that takes place by a law enforcement person, and they use their badge, what we call depriving that person of rights under color of law, using the law and their status and their position to protect them, and saying that they were just merely carrying out their job. But if they were carrying it out in an instance where they were discriminating, or they did that because it seems quite apparent that that person has a pattern of stopping certain kinds of people, then in that situation then happens. So you have racial, sexual preference people, and all kinds of it. The bottom line is, what are we saying here is that people should be protected under the law equally, under the Equal Protection Clause of the Constitution. United States versus Lanier upheld a conviction of a judge. Now listen to this. The judge was convicted for threatening a woman to deny her custody because if she didn't give in to him sexually, then he would deny her custody. Well, that's operating under color of law because he's using his position. So the court ruled, the Supreme Court makes common sense here, that the judge acted willfully under color of state law and deprived the victim of their constitutional right to be free from sexual assault, period. Makes a whole lot of sense. Hate crimes, when we get to the point of hate crimes, it's not, a crime involved an offense that could ordinarily be a misdemeanor or not as serious, but it escalates and rises to the level of a hate crime when the reason why you committed the offense on that person is because of their race, ethnicity, gender, or sexual orientation. And they're promoted by people's the bias against those individuals. And it could be offenses against property or persons. And so then there came the federal law, the Hate Crime Prevention Act, which eliminated the requirement that the victim be engaging in a federally protected activity. So the federal government steps in situations where the individual doesn't have to be in the federally protected activity. They can be just doing everyday stuff as individuals. So in most state courts, criminal penalties, as I said, are enhanced when a person, they elevate it to a hate crime. You hear that a lot now, unfortunately, with the things that are happening now in our country. It's a sad thing. So that's all on that chapter. We've got about 25 more minutes, and I'm going to do the next chapter. Do any of you have any questions about this chapter before I go to the next one? Any questions? Brenna, no? Okay, very good. Okay. I hope this has been helpful. I know there's stuff in there you say, aha, now I see how to do some of the assignments. That's why it's good to come. Yeah, you can hit the archive, but then you're going to get it firsthand now here, and then you have an opportunity to ask a question. But I try to make it pretty clear, and I use my expertise in what I've done. Criminal law is like my ace. Okay, now we're going to shift from properties against persons to property crimes. Now, be aware of the fact that you're going to notice a pattern here, that the crimes against persons are considered more severe than properties against crime. Why? Makes common sense. Glad you asked. It's because of the fact that individuals' lives can't be replaced. Property can be replaced or can be recovered, but sometimes the injury that's done to an individual on their person it travels with them for the rest of their lives, such as assaults and rapes and beatings and things of that nature. So let's go through these as many as we can before 10 o'clock. So larceny, what is larceny? Larceny, taking somebody's personal property, something that don't belong to you. And it was it originally led to be violating the law, and someone would have a civil case, not a criminal. But larceny began to move towards theft, and larceny applies. It applied to tools, household items, and domestic animals. That was at common law. But statutes have changed that, and you don't hear larceny that much as you're going to see. False pretenses, obtaining money or property through misrepresentation. You're going to see where people are able to commit identity theft, fraud, and things of that nature, which would normally fall under false pretenses. Embezzlement, using your position of trust, taking advantage of the person that you're supposed to be taking care of, and converting the money for your own personal use, and that the other person that is supposed to be receiving the benefit doesn't receive any of that. Prosecutor just had to prove that the accused intended to defraud the victim, and also receiving stolen property as well. Buying that stuff that people would say, oh, it fell off the truck. That's an old saying. It doesn't mean it literally fell off the truck. It meant that it's hot property and that it was stolen. Okay, here we come to the modern, and I told you about larceny theft approaches. Modern theft includes larceny, stealing of vehicles, shoplifting, looting, carjacking, and extortion. On the federal level, we have in Chapter 18, United States Code, annotated. Now, be aware of this. Chapter 18 of the United States Code contains most of the criminal code. It's normally known as the criminal code to us in the criminal law business, that on the federal level. So, and when it says United States Code annotated, it means that there's a statute and then there are cases that were decided where that statute section came into play in a case. And so 641 says places crimes so kindred as to belong in one category. Embezzlement, theft, receiving stolen goods would be found under that section. 659 provides penalties for embezzling or unlawfully taking the contents of any moving interstate or foreign commerce from passengers therein. So if you rob on a plane, a train, or you could have a vehicle that travels across state lines, a car or a truck or anything like that. Okay. And then this is a chart. I'm not going to go through it, and I'm just going to skip through it. You can look at that at your leisure. It just basically says how larceny was broken down in early Parliament and then how now, as I was just telling you a few minutes ago. Now we got things like credit card fraud, computer fraud, identity theft, grand theft auto, because the value of cars have increased, looting, shoplifting. These all fit under what originally was larceny, and it shows you how they have branched out and what they've become. Okay, now. So modern approaches to theft. All states now include tangible and intangible property, such as, for example, taking an idea, copyright, patent, or something that's intangible, and also taking somebody's tangible property, laptop, phones, anything, clothes, stuff. Newer statutes include other crimes besides theft and impose penalties based on the value of the item that's taken as to whether or not it's a felony or a misdemeanor. Grand theft is the most serious. Petty theft is a serious misdemeanor. And then the idea of theft, listen, pay attention, pay attention. Theft is merely what it says here, the willful idea of taking goods or services from another without permission or authority of the law. Goods or services from another without permission or authority of the law. That is theft. For example, I had a case one time. I represented a young lady, and she was in college, and she was with some friends, and they were in a store, and they did this thing called, they took the tags for an item that cost more and put a tag on for less. And this doesn't happen as often now anymore because of the scanner and so forth and so on, but this was before scanning was really big. And so as a result, what that person was really doing was committing theft, because they were getting an item that maybe cost $50 and putting a tag on it for $40 or anything less than that. Then they were depriving that retailer of the full value of what they really should be paying for that. And so that's theft. That's theft. The person I represented did not participate, and as a result, I got her out off on proving that she did not participate, even if she was with them. And so, anyway, the bottom line is that you don't want to do that. I have people say, "Oh man, that's the deal." Now that's different from going, for example, and saying to the person, "Hey, this was in the section where it cost this amount," but you're going to say somebody that no, you're going to make me pay the full price. Well, generally, in many instances, that retailers will, for goodwill and also understanding following the civil laws, will allow that individual to get off with it because something was labeled differently. I had a situation where I went and bought a item, and then I got a warranty, and the warranty price was less. And then when it hit, they rang it up, it was more. And I went and showed them where it said on the sticker under there that it should be the least. But what has happened is that was some old information, not my problem. So I got it for less because of that. But that's not the same thing as what I said, because I wasn't intending on defrauding. I relied on that in making my purchase and choice. It's a different total ball game. Embezzlement. Here's an example. There's this guy named Bernard Madoff who created what we call a Ponzi scheme. And what's a Ponzi scheme? This is an attempt to get people to entrust money to invest about something that doesn't even exist at all. And so this individual, believe it or not, cheated people out of $18 billion in the 70s. And there were many middle-class persons. It wasn't just, people who shouldn't know. But he was so well how he set it out that he persuaded these people. And so he was later on convicted, and he's still in prison now. They did a movie about it. And 2009, he was convicted of 11 federal felonies and sentenced to 150 years in prison. So he's gone for a while because there were people who lost their life savings, as it says here. Robbery. Now, here we go again. I've told you what theft is. I'm now telling you what robbery is. Robbery is making sure you get these elements. The crime of taking property or money or property, listen to this next part, from a person, 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 from a person. Professor Wright, why you keep saying from a person? Because it means what it says, from a person, against that person's will, by means of force or intimidation, force or intimidation. So there are two aspects that must take place in order for robbery to be the proper charge. From a person and by means of force or intimidation. Both of those requirements must be met. Not one or the other, but both. Okay? That's robbery. Under common law, robbery was an aggravated form of larceny or theft, as we were talking about. But that has changed. That has changed. Force or violence have to, people, happen before or at the time of the taking of the property. Okay? Offense against that person, and we're talking about offenses of property, but that person is involved because it usually involves some form of assault, and we already talked about that, or some form of battery. One or the other. Got that? Think about that. Let that soak in. You go through your discussion post. Let's go back here. Did I get the right one? Okay, federal laws of robbery, bank robbery. Is the federal law to rob a bank. That's when you get the feds involved. Prosecution only needs to establish that general intent, not specific. State laws, some states have codified the common law. Other states classify robbery according to the degree. But for our purposes, I already told you about robbery. Aggravated robbery, think about that because you used a weapon or an item. Now, remember, again, the definition doesn't require that you committed aggravated, but that person could be placed in fear of injury or actually injured as well, okay? In this case here, here's a good one here. Okay, this person had an unloaded weapon, and the Supreme Court was asked whether an unloaded weapon is a dangerous weapon. Well, a little common sense to kick in here, and I'll give you an example of an instance where when I was a police officer, what happened after I cover this a second here. The display of a gun instills fear in the average citizen, or person, I should say. As a consequence, it creates an immediate danger that that person is subjected to violence. Well, in this case, McLaughlin and his companion robbed a bank with an unloaded gun. Now, they tried to use in their defense that the weapon was not dangerous and it was unloaded. Let me say this. It is not for you to determine whether or not it is. All you know is this is a weapon. And unloaded weapons, too, have been known to cause people to go into cardiac arrest and have heart attacks. But let's aside from that, it's irrelevant. Let me give you an example of what happened to me. When I was a police officer, and I didn't wear a uniform, I always wore plain clothes because I was an investigator. And I had a young man walk up to me in broad daylight with pull the gun on me. And he said, "Give me your wallet." So I told him, I said, okay, and I'm talking to him. I'm using all the training that I knew how to, try to keep him occupied. I said, my wallet is inside my jacket. And so I had on a suit jacket, so I reached inside. But what I was really doing, instead of reaching for my wallet, I was unbuckling my gun. I had a Glock. And so I pulled that gun out. And when I put that gun on him, it startled him. And I said, "Drop your gun." And he did. I said, "Kick it over to me." So that individual gave me the weapon. And he was standing there. And I still had my gun on him. And I picked up the item. It was not a unloaded gun. It was a toy gun. Now, was it a dangerous weapon? Yes, because it placed me in fear of a consequence of immediate danger. It wasn't my call to determine that it was a toy. He wasn't operating with it like it's a toy. He was operating with it like it was a real weapon. And that meant to me as a law enforcement officer, I had every right in the world to empty my clip or shoot him and to protect myself, but I did not. But the point of the matter is that I'm bringing is that it was relevant that was a toy gun or an unloaded gun. That's the point. So it's not relevant. Carjacking, yeah, we already know what that is. But the we used to just call it theft of somebody's car. But now carjacking has been statutorily defined, makes it a crime to take a car. And there's a federal law involved as well. 18 U.S.C., I told you, carjacking or attempted carjacking, attempting to take and resulting in bodily injury. Taking a car, and you hear it all the time now. People are being forced to get out of their cars. They're at the gas pump, they take cars. It's a general intent offense. All you have to prove as a prosecution is that the car didn't belong to that person and that they took it by force or violence or some intimidation of that individual. Holloway versus United States affirmed the federal carjacking law as applied with the conditional intent of harming drivers. Holloway was convicted of carjacking, and his attorneys and his approached, not his attorneys, the scenario was that they approached the vehicle and threatened, here they go, to kill the individual if they didn't give them their keys. Trial court told the jury in terms of this case that the conditional intent requirement was met by as long as the defendant intended to cause serious injury or death. And so that's why it says it applies, carjacking also applies to the conditional intent of a person when they perform a carjack. A difference between robbery and extortion, we already went over this, taking money from a person against that person's will by means of force or intimidation. Extortion, on the other hand, obtaining money or property by threats of force or the inducement of fear. There's a difference. There's a difference. It's not from the person of the individual. It's also called blackmail. Property is taken by threat. Property does not have to be taken from the victim's person. It requires specific intent. On the other hand, robbery is taken by threat, and as felony is taken, and the requirement that I stressed earlier, taking the property from the person or immediate presence. Now, immediate presence. What is immediate presence? That's an issue that you're going to have to decide. I know the answer to what it is, but you're going to have to decide. Is it immediate just because the person saw them? What immediate presence means within the vicinity of the individual, and I mean within the area where that person is physically located. That's a query question, but it requires general intent. General intent. General intent. The research gives you the answer to that question. Remember, people, one of the things that we try to do as professors, and this is what I try to not spoon feed you the answers, but get you to do some thinking and applying the factors that help you reach the conclusion. That's what we call critical thinking, and that's what we're developing you into critical thinkers, because that's what employers are looking for. Forgery is simply the crime of taking an instrument written and changing the instrument, or changing grade on a transcript. Under federal law, the prosecution must prove the intent to pass bad money. Counterfeiting is making an intimidation of something with the intent to deceive. By the way, did you not know, don't Xerox money? Don't make Xerox copies of money. That is a federal felony. A lot of people know that, but some don't. Got just a few more minutes, but I'm going to go ahead. Okay, this is an interesting scenario here. We're talking about forgeries here. Here's a situation where these diaries of Hitler were presented. And let's chew on this a little bit. The popular West German magazine Stern made this announcement that they had 52 handwritten diaries from Hitler himself. Well, the contents of the diary is alleged views about his character and presented him as more than people had already thought. Many who had known Hitler personally were shocked because they didn't believe these diaries. They experienced firsthand the atrocities committed by him. So here's what happened. A few weeks after it was discovered, the diaries were forgeries. Well, what do you mean? What happened? Here's what happened. Even though the Stern had asked an expert to verify the authenticity of the documents, unfortunately, the expert's compared the diaries to original documents, what they had, that were also forged by the same person. So if it's original and was forged, doesn't make it authentic. That's the point. And then uttering a forged instrument, such as a check when intent to defraud, instead of the actual forgery, but the passing of the forged check. Knowingly delivering a check that you know is forged is generally classified as a felony. And it's 10 o'clock, but hang in there a second. Worthless check, you know, writing bad checks and things of that nature. Okay. Let's see if there's anything else. Okay, now, this you need to take a few minutes to get, because it goes again. We already covered theft. We covered robbery. Now we're going to cover burglary. At common law, breaking and entering of the dwelling of another. There used to be a requirement, a nighttime requirement, but burglary now can take place during the day. A person is guilty of burglary regardless of lawful entry of the dwelling. So what it is intentionally remaining, like for example, in a department store with intent to commit an offense after the store closes. I had a client that did something crazy like that, and he dressed himself as a ninja and came out after the store was closed, tried to rob the place. It didn't happen. So that was considered as burglary, not just robbery. And then they were chasing him, so he jumped through the store window and passed out, and that's where he was arrested. So that was one of my crazy cases. But anyway, that's burglary. Now, listen to this. Home invasion is where a person armed with a dangerous weapon or persons are present in the home at the time of the break-in. Remember, that's home invasion, at the home. The possession of burglary tools, if the possessor has the intent to use the tools for burglary purposes. Now, before I get to arson, let me go back to burglary 1 second, because I'm going to wrap up here. Burglary is still burglary if you penetrate the plane of the property. For example, if I have my laptop sitting on my desk, and actually, if you could look to my left, there's a window here. But I got a balcony, so I'm high up. But let's see if I was on the ground level, and I had my window open, and a person reached in and took my lamp or that. They committed burglary just by reaching in. They don't have to physically come in to commit burglary. There we go. That's all I'm going to say on burglary. Arson, we already pretty much have an idea. Intentionally burning someone else's property. And then there are instances where there's individuals who commit are serial arsonists and so forth. And then, okay, malicious mischief, graffiti, turning on the gas, water, or something after they've legally been cut off and you hook them up yourself. There are defenses to property crimes, where a person takes the wrong jacket, for example. That's a mistake of fact. Mistake of law concerning a debate about legal rights and ownership. The person didn't intend. They have an alibi and they really didn't. They're insane. Well, that's a whole nother issue. The rest that they were forced to do it, or they were intoxicated. Depends. If there's involuntary intoxication, they might have an issue. And if they're not, it's not. Most of these don't fly. And so it's 10:04, and I finished, went 4 minutes over. So now I am going to go back into the classroom. And that was it. That's it for the week. You got the assignments. You got some help with your discussion post. You got some help with your written assignment. What else can I do for you? And I'm not delivering pizzas and stuff like that. So, okay, guys. Any questions or comments? Anything before we adjourn? Brenda? Okay. Catherine? You good? Okay, great. Well, that's my goal. Again, I am disappointed that I don't have. I got almost 26 students, and just keep coming. I will prepare an archive for the students that aren't here, but you guys have an edge on it, and I know you guys. That's a good thing, okay? And that could be a bad thing, but in this instance, for both of you guys, it's a good thing. So, 2 thumbs up, okay? All right, all right. I'm not going to get into specifics because I'm not being charged with a violation of FERPA. Okay. All right, guys. Enjoy the rest of your week. And remember, next week there is no lecture, and that we got 3 more lectures to go. The next one is in week 6. So I'm going to say good night because I got some grading to do as soon as I release, and say, you're welcome, and have a good night. Okay, so I'm going to end this session. All right, thank you, both you guys. My pleasure. I love it when students attend the lectures.